Hey everyone, and welcome to this training. You may note that about halfway through this training, we suddenly have guests and questions. That is because I forgot to record the first half. So instead, I'm re-recording it, so it's just you and me, and then you'll see them jump in a little bit later. So I apologize for that, and you'll see the stitching. All right, well, with that, let's jump into this. So we're going to be talking about the 2022 Washington legislative session and how it relates to the Rentwell curriculum. So the changes that you will see in your books and then how to talk about them through class. This presentation was created by Angela Huddleston, who is the landlord liaison over at Transition Projects, and also myself too. Just so you know, neither of us are lawyers, but we're also not cats. In Washington, we were tracking 27 total bills this legislative session. Of those, 20 of them died, and then 17 passed. So we'll be going over the really specific ones that relate to the curriculum, and then we'll do some honorable mentions as well. So those that do associate with the curriculum that we need to spend quite a bit of time on is, congratulations, you just passed just cause evictions. So this eliminates almost entirely no cause evictions. There are some more reasons to evict within the state of Washington. So we'll go over all of the reasons to evict now that are on the books. We'll talk a little bit about rental assistance funding and the bill that was passed for this, but more so what we'll do is we'll tie it into this next coming bill, which is the right to counsel. And then there's some additional COVID protections underneath that too. Then we'll talk about extensions to protective orders, as well as limited license suspensions. And like I said, the honorable mentions. So just so that you're aware of, at the moment, the eviction moratorium still stands within the state. So an individual can't be evicted for non-payment of rent or debts owed to landlords within the COVID period. So March 1st, 2020, all the way up until now. This will go through the end of the month. And what we know at this moment is that it will end on June 30th. And then come July 1st, people will owe not only current rent, but they'll also owe back due rent too. And we'll talk about some of the programs that were set up to protect people from mass evictions during that time. It is still very likely that Governor Inslee may come out and do another executive order, which extends this moratorium. We just don't know that just yet. When those extensions usually happen is several days before the moratoriums end, as we've seen in the past. However, federal-wide, that eviction moratorium is coming to an end at the end of June. I know that Oregon's is currently set to expire at the end of June as well. So what I'm seeing kind of nationally and locally is that it's likely that these moratoriums will end by June, by the end of June. And I'll keep repeating this too, because some of the laws that we see here kind of counteract one another. So we'll talk about which one is currently law and then what one would be going forward come July. The first bill here is the just cause eviction notice. This one was a pretty big deal for your state. So goodbye and good riddance to 20-day no cause notices. Woohoo. When it comes to these just causes, like I said, it eliminates those 20-day no cause notices in most cases. It provides us 17 reasons to evict somebody within the state of Washington. Some of those are new. And it is currently law right now. However, this law isn't as protective as the eviction moratorium. So as long as we've got an eviction moratorium, that stands. But the moment that that lapses or falls away, this comes into play. So let's talk about those mostly times. There are some exemptions that were carved out in this law that would create new eviction notices for no cause. They will not be set at 20 days. They'll be a little bit longer than that, and there's still one remaining 20-day no cause notice. So the specific exemptions right now through this particular bill and what that looks like is it still allows no causes that are, there's 3 different types. If there is a 6 to 12-month lease and it is the very first lease between that landlord and tenant, and after that, that lease would automatically roll into a month-to-month. So as long as they're within that initial long-term lease with that landlord, if come towards the end of that initial period before it reaches month-to-month, the landlord just goes, I just don't think this is a good fit. And then they can use one of these no cause exemptions. So that's number 1. Number 2 is if the initial lease with the landlord is 12 or more months long and there was never an option to renew. So let's say that the owner knew eventually they would be selling the unit, but it would be in the next year and a half. So they're going to rent it to somebody in between that, but they know that within 18 months, they're definitely going to sell. So the lease is only set for 18 months. And then after that, there's no plan for it to go to month or renew into a longer term lease. That's number 2. And then the third one here is this would be a lease between a landlord and a tenant that at the initial phase, it's at least 6 months long or longer. And then after that initial term, they decide to go into another long-term lease of another 6 months or longer. So it would never roll into month-to-month, never ever. But it's an ongoing, continuous, successive long-term lease agreement. In any of these situations, a landlord can still use a no cause eviction notice. However, like I was saying, those notices aren't 20 days anymore. They're 60-day notices. They have to be in writing, given to the tenant, and they can be given the same way that they would give eviction notices right now. So it can be handed to them. It can be mailed to them. It can be handed to somebody within their household that seems of a reasonable age, or it can be mailed and posted somewhere pretty visible. Usually that's a front door. The notices cannot change the lease period currently. So it can be given during that lease period, 60 days before the end of that lease period, but it can't change the end date of that lease period. So it can be handed to them, but it won't actually go into effect until the end of that lease period. It's possible for landlords, if they want to give a 90-day notice, they can do that, but they need to give at least a 60-day minimum notice. Most of the time, you'll see people just give those 60 days. However, I do want to call out something very important here. Danger Will Robinson. So landlords have this reset grace period. So whenever the eviction moratorium ends at the end of June right now, right? So July 1, it is done. Then landlords have a 3-month window to then any leases that they currently have, they can convert into one of these 3 leases above. So they can make it into a long-term lease, even if it's month to month. They only have 3 months to do that. So that would put them, if we start July 1, that puts them at the end of September. But come October 1st, they can no longer use this anymore. So they have to do it within the 3 months or they don't get another shot. This would be something where even if somebody was living in a household for the last 5 years on a month-to-month lease agreement, it doesn't matter the length of how long they've been living there, that landlord can go back within this 3-month chunk of time and say, I'm going to change yours into a 6-month lease with a possible option to go month to month after that. Or, a 6-month lease that will then roll into another 6-month lease. Right now, unless it's set in the lease terms, every lease will automatically roll over to month. So unless the landlord specifically calls out that we are not going to ever enter into another lease agreement, or if they say in the lease agreement, this is a 6-month lease with the option to renew for another 6 months at the end, that's fine for them. But if there's no language in there, it's an automatic month to month. So those are the exemptions carved out into this. Now let's go over the 17 reasons to evict. Some of these are going to be ones that you've already seen in your book. Some of them are going to be new to the book, and some of them are going to be entirely new because of this law. And we'll talk about the differences of why that is. So the first one that you know really well is the comply or quit. The tenant has violated the lease agreement, or a household member or pets or guests, and the landlord wants them to change the behavior or leave the unit. This would be a tenant-based behavior reason to evict. It's a 10-day time frame, and this is already written into your book too. Another one that you know really well is the pay or vacate. Rent is late, please pay rent within 14 days or please leave the unit. Tenant-based issue or a non-payment, 14-day notice, also in your book. Right now, remember, with the moratorium, landlords cannot use this one. There's comply or quit. This means that the tenant, household member, guest, pets are misusing the property. There's really big concerns about how they are, the safety of the property, how they're handling that lease. At this point, the landlord just wants them to vacate. They are a serious concern. It's a tenant-based reason to evict. It's only 3-day notice. Also written into your book as well. All right, now we get into some new stuff. Number 4 here is the refusal to enter into a new lease agreement. So the landlord is offering a reasonable lease agreement to a current tenant, and the tenant is refusing to sign it. It's a sign or leave situation. The tenant is given 30 days notice. This, I think we will see a spike in the use of this particular eviction notice because of that 3-month window where a landlord can choose to convert somebody's lease agreement. This will remain on the books after that 3-month window, but I think that's when you're going to see that the most utilized. One that we do talk about in class is lying on an app. The tenant has knowingly or unintentionally lied on their application. And if they had told the truth, the tenant would not be allowed to live there. They would have been denied. Somehow they got through, but then the landlord found out afterwards. This is a notice to vacate the unit. It's a tenant-based behavior reason, and it's a 30-day notice. This will be new in the book when it comes to section 12. We do talk about it for a moment in section 6 when you talk about the lease or the signing the rental agreement. And so it comes up as a little tiny pop-out of what the law says on section 11 or section 6. Section 6 of your book, page 111. So right now what the book says is it's a 10-day notice. If you want to strike that out and put 30, that is the correct one. All right. Other ones for you is there's the 4 strikes. And this is a brand new one. This comes out of this specific law. This means that the tenant has violated the lease agreement, even minorly, but continuously, 4 or more times within 1 year period. At this point, the landlord is not interested in giving them more notices to change their behavior. They just want them to leave. Now, those 4 times have to be well documented to the tenant, so the tenant is aware that their behavior, if continued, may cause an eviction. Once somebody gets this, it's a 60-day notice to vacate. There is no real remedy to it. It's a tenant-based reason to evict. Another one that is new to us is the SO disclosure. So a tenant is required to register as a sex offender or has failed to state or disclose that they're a sex offender. Therefore, they need to vacate the unit. This is also a 60-day notice too. There is unwanted sexual advances from the tenant towards the landlord or anyone working for the landlord or property manager. But this could be sexual advances, or this also is the tenants have done this behavior and it falls within harassment of a protected class also. So at that point, it's a vacate the unit, tenant-based behavior, 20 days. This is new to the book, not necessarily new to the law. Unauthorized occupants, also new to the book. An individual who is the main tenant of a household has moved out. Landlord goes to turn over the property so they can re-rent it, and surprise, there are still human beings living in there that they didn't necessarily know about. This would be a situation where those individuals, if they've been living there 6 or more months before the main tenant had left, prior to that, then they have the ability to possibly apply and get approved for that unit, or it's a 30-day notice for them to vacate as well. So it may be that the landlord has already rented out that unit, not thinking anybody is there. So they may not have even the option to apply. And then the roommate removal too. So this means that the landlord and tenant are sharing a unit where they're sharing common spaces. So a common kitchen or a bathroom, and they're just not getting along anymore. The landlord wants them gone. This is the only remaining no cause notice that is 20 days long. This will be new to the book as well. In this situation, it's very important. It's not tenant to tenant, and one of them is the primary tenant that has a connection with the landlord. It's that one of them is the owner of the unit and the other one is paying rent directly to them, or is their tenant. And it's also very particular that they share common spaces. So if somebody has converted their basement into its own standalone unit and they don't share those spaces, this can't be utilized. Or if they're in an ADU unit, they have to share those common spaces in order for this to be the notice that they receive. There's also end of programming. So this is specifically related to nonprofits that have transitional housing or programs related to housing, and that program is ending. So somebody is graduating from the program or phasing out of the program. It's a programming-based reason. It's a 30-day notice. You've also got the unit is inhabitable. So the unit has just been so ill taken care of that it is just not a safe space for an individual to live in anymore. Ideally, an individual would get up to 30 days to live in the unit, but if it is so unsafe, it may be less than that, depending on their safety. And this is it specifically being condemned by a local authority. It can't just be the landlord or the tenant being like, this isn't safe and moving out. So it has to be a local authority stepping in and going, New ones also include the owner wants to move in themselves. So this can be the owner or an immediate family member wants to move into the unit and there are no other adequate units available to them at the moment. Immediate family members are really important, like their son wants to move in or their grandma wants to move in. Even grandma feels like a stretch there. Their mom wants to move in. It's not like brothers, sisters, cousins, uncles, nephew, niece wants to move in. Like it has to be immediate family members. And it's important to know that if there are 2 units available and they're the same size and one of them is currently vacant, they can't just kick this tenant out and take this unit if that unit was vacant and still of the same quality. It's a 90-day notice in this case, and it's a landlord-based reason. A similar one is that the landlord wants to sell the unit. They've decided it's time to move forward and not be a landlord anymore. They've decided to sell the place. They give the tenant a 90-day notice. And within 30 days of that tenant exiting, they need to have made a reasonable attempt to sell the unit. So they need to have it on the market. They need to move forward with that. They can't just say, I'm selling the unit. Here is your 90-day notice. And then after the tenant leaves, go, oh, I changed my mind. I really like this unit. I can't wait to have another tenant in there. They can't do that. They have to make all reasonable attempts to sell it. Oregon has a similar one, but ours carves out specifically that they have to accept an offer of sale on the unit, so it goes even further than this one. Another newer one is they plan to demolish or change the unit. So they're going to demolish it entirely or make substantial changes to the premise or change the primary use of the premise. They want to turn it into a 7-Eleven or they want to turn it into a bed and breakfast, like serious changes. And this is really particular that it can't be like, oh, I just want to paint the house a different color. It needs to be serious repairs where somebody can't stay there during that time. So they want to take off the entire roof or they're going to raise the house and put another story under it. Those are the massive changes that can happen there. An individual would not be able to live through those situations. So they would have to be asked to leave. This one is a 120-day notice, so it's one of the longer ones on the books. Another long one is condo conversion. They've got a house, they've decided to put a wall straight down the middle and make it into 2 separate homes and living spaces. That is a serious renovation where somebody wouldn't be able to live there at that time. So they're going to ask somebody to leave. It's another 120-day notice. Oh, and then lastly, and the very last one they have on the books is there is another legitimate reason in an economic-based way or a business-based related reason that is not covered under this law that the landlord just needs the unit to be vacant. So I was asked in the training to give an example of what this may look like. And what I was coming up with is, so if somebody's mom is really sick and lives out of state, and they're trying to liquefy their acids and kind of reduce where they're currently living so they can move closer to mom to take care of mom, but they're kind of in the middle of it, so they're not planning on selling it immediately. They're not planning on moving their mom into here, but they need to make sure that they have all their finances in order so that they can continue to take care of mom's medical needs. This would be another economic or business related reason in which the landlord may want that home vacated so that they can possibly get ready to sell it or kind of come up with their next plan there, have it demolished, things like that. In these situations, it's a 60-day notice from the landlord. However, the landlord has to prove that this is a legitimate cause. So if the tenant does go, I'm going to see you in court about this one because I don't trust your legitimate reason, then when they go to court, the landlord has to prove what that legitimate reason is. And the court can go, you need to tell me a little bit more about this. So I'm going to extend that eviction another 60 days. So it could start at a 60-day notice and it could end up at a 120-day notice, depending on what the court says. So those are the new 17 reasons, or some of them are older, but these are all of the reasons that one can be evicted in the state of Washington at this point. So when you see the comment new to the book, what that means is I thought that I had done a terrible job and not gotten all the forms from Multifamily Northwest and put them into the book. And upon my research, I have all the forms that Multifamily Northwest have created for Washington. And then I went, I'm going to check the court systems and see if they have some forms too. And I couldn't find them through the courts. My big concern here is that none of these are like formulated template notices that are given to the landlord or given to the tenant, meaning that every landlord can kind of come up with their own written notice around these, and hopefully they're correct and accurate to the law. And that's really, really terrifying to me. Perhaps with the passage of this new law, what they'll do is standardize it within the court systems, and then we'll have notices and copies of notices for all of these. How this is going to impact your book is there's really two different places where a lot of this information is going to be dropped in. As you can imagine, my ever-changing page in section 8, when we talk about long-term versus month-to-month lease agreements, that one will get transformed, as well as, surprise, surprise, pretty much all of section 12. So I'll make sure that we add more of those within this. What I will say is we're currently still working on getting the online version of Rentwell up and running next month. This feels so close. So that's kind of my focus at the moment. I know that my plan is to have new updated book versions for both Oregon and Washington by January 1st, 2021 or 2022. And so what I would like to say is that between now and then, I can at least recreate a section 12, and then you can have that as an insert into your current book. So you can teach out of that section 12 with all of these being accurate. So once the online curriculum is done, then we will move forward and I'll try and create that for you so that you have it available. You will also get all of these slides as well. So you'll have a copy of this too. And then from here, because we don't have an audience for this section, I think this is exactly where I get to jump in to us then meeting up with the rest of the group. I think that was where I forgot to intersect these. So I'm going to go on to rental assistance and the bill that helped create rental assistance. Like I said, I'm not going to talk that much about this. I tend not to focus that much on the money bills, but what they do with the money, and we've got those slides coming up too. So rental assistance for past debt, this just created a new funding source to provide eviction prevention and housing stability services. This went into effect or will go into effect next month. What it does is it bolsters the money that goes into the eviction prevention programs. There's a few of them currently around the state, and there's an opportunity to provide more, as well as it then brings in funding for agencies that are working across the state, specifically with other agencies that are related to population specific or culturally specific agencies, to make sure that they have funding to support the folks that they work with. The funding itself can be used for rent assistance, utility assistance, or administrative costs. So staffing people so that they can get out that services and those costs. Eligible folks for this would be folks with kids, individuals who are doubled up, seniors, young adults, chronically homeless individuals. And it's not necessarily that every agency that's going to get some of this money needs to serve all of those individuals. It's just in general, those are the populations that they're working with. So that's the funding source. But what it funds, see, told you I would only spend a little bit of time on that, is the right to counsel. Woohoo! Congratulations, you are number one. You're first in the nation to get this type of bill. Congratulations. What it does is it provides an eviction prevention program. This is already a program that has been piloted. I'm going to have some more water right now. Piloted in several different counties. I did happen to just highlight the counties that do have Rentwell in them, just so you're curious. It was a program to help individuals who were receiving eviction notices to then have some mediation there, maybe some legal services to try and prevent those evictions. The funding for this program is going to roll out slowly. However, they think they have funding at this moment to then start July 1 and getting this operational or continuing on the pilot programs that they already have in those counties. They think that this can be fully operational by the end of this year. There are some caveats to that. So what this provides is it provides legal representation for individuals who are low income or indigent, who are facing evictions for non-payment of rent currently. So when they have to start paying rent after the moratorium, or if they have any debts during the COVID time. So last March to now. It's really important to know that this program is very dependent on the funding that they have, as well as this bill allows counties to provide these services. It doesn't mandate that they provide these services. So now counties have the opportunity to connect with this and provide it, but that doesn't necessarily mean that they have to. They get to expand if they choose. And then what this means is when landlords are able to give those 14-day pay or vacate notices, with those notices has to be a notice of disclosure saying, there's a program out there to help you. Please call this number or go to this website to receive help for this eviction prevention. So
that's with any eviction, I'm sorry, or that's for a 10-day notice?
That's for the 14-day notice, because remember, these ones are very specific to non-payment of rent or past due debt. And right now, those 14-day notices can't be given out because we're in COVID moratorium. After COVID moratorium ends, then we might start seeing these. So indigent is somebody who is earning less than 200% or less of the federal poverty line. Low income in this is defined as anybody who's receiving public assistance. And then it's really specific that it is a tenant who is in an eviction process. So the tenant has to be somebody who had been living in a dwelling unit meant for living at least 30 days before COVID. So 30 days before March 1st, 2020. And an eviction notice has been filed against that person. This can't be pre-active that they're trying to not get that eviction notice. The eviction notice has to already be given to them.
I think that 30-day before COVID, that's a really important piece.
Yep. It's also important that if there were individuals who are living in hotels or motels or campsites, all of those qualify as well. but it's still that 30-day piece that they've needed to be there during that time. Another really exciting piece to this is somebody's immigration status does not matter in this. Programs can support regardless of their immigration status. Some programs, depending on where they receive their funding at, may not be able to help, but overall, the program wanted to provide that that wasn't a caveat that somebody had to be a US citizen to provide these or get these services.
Do you think that would include someone that's parked on the street?
It's got to be a place that's meant for inhabitation.
Oh,
So
okay.
if they're in a car and even if they're in an RV, I think that that would be a hard sell at that moment.
Okay.
Yep. It is really important to know that tenants need to advocate for themselves here. So when they receive that 14-day notice, they'll also receive the, hey, there's a program for this. They need to let the landlord know and the court system know that they are going to seek help with that program. If they don't let those folks know, the court is going to move forward with its proceedings anyways and move forward with the landlord being the one who gets the unit back and the tenant owes them money. So they need to let people know. Either the courts or the judge will inform the tenants of their rights to counsel. They can't expect that to happen if they go to a hearing. They need to be asking for counsel when they go to that hearing, though. So they demand their rights. They may not have a lawyer right there on the spot to help them at the moment, but then the judge can choose to just pause on this hearing, schedule it out for the future so that person has the opportunity to seek counsel. And this all begins July 1st. Tenants who do receive that non-payment of rent notice, they can call the eviction defense line or go to this specific website. And like I said, I will send it out to you too. I imagine for those of you that are working with folks in Clark County, because Clark County was one of the pilot programs, individuals can start calling as of July 1 and know that there will probably be a program there in their area to support them. All right, pages of the book that this impacts. We're going to talk about it in section 4 when we start talking about what a landlord is looking for when they're doing screenings. So screening criteria, debts to past landlords, things of this nature. If they received eviction notices, that's a good time for you to mention all of this. As well as then in section 12, there will be a brand new call out box on that same page that talks about what the difference between an eviction and a notice is. I'll put a bold little print there. And I will probably add more information when you talk about the 14-day notice too. So you'll know, you'll have multiple opportunities throughout the curriculum to talk about these. Okay. There were other protections in this bill too. So all of that was super cool. And we get some other stuff too. Woohoo. So repayment plans is a part of this. Governor Inslee had made payment plans be a thing through the moratorium as an opportunity that somebody needed to enter into a payment plan with their landlord and couldn't just move to a direct eviction. What this is going to cover is any rent that occurred between March 1st, 2020 and either, so there's two different opportunities here, 6 months after the moratorium ends. So if it ends the end of this month, that would be December 31st, 2021, or at the end of the public health emergency, whichever one is longer. So if Governor Inslee decides to go, I'm going to put another moratorium on this. I'm going to do it through the end of this year. And then maybe halfway through that, they're like, I'm going to do this until March of next year. As long as that is the longer one, that's what qualifies there. So.
I
And
have
so,
one question. So
yeah.
the repayment plan, so just to clarify that last bit.
Mhm.
So it's for rent. So for rent that's unpaid up to 6 months after the eviction or after the moratorium?
During the moratorium or up to the 6 months
6 months,
after.
got it.
So it only covers rent. If somebody owes different fees to their landlords, it doesn't necessarily cover that. The repayment cannot be more than 1/3 of an individual's monthly rent. So the landlord can't be like, now you owe me 2 times the rent until you're paid off. That's not happening. 1/3 at the most, but we'll talk about that in a moment too, of where that comes into play about being reasonable. The tenant, it must give tenants at least 30 days to start paying this. They can't give the notice to the tenant being like, hey, here's a repayment plan. Cool, you owe me the money tomorrow. That's not acceptable here. It needs to give them at least 30 days to start this payment plan. The landlord also has to allow for if there are promissory notes from third-party nonprofit agencies who are willing to pay that debt on the tenant's behalf. So the landlord can't be like, no, that's not money in my hand. I don't care. As long as there's that promissory note from the third party, landlord has to count that the same as cash in hand. And the payments have to be reasonable. The plans do. So both in a reasonable schedule for repayment. Like I said, they can't just be like, you owe me twice a month worth of rent tomorrow, and we'll just go from there. And the amount has to be reasonable. So here's the tricky thing with the amount. So even though I said that it cannot be more than 1/3 a person's monthly rent, it may be, let's say that somebody has $1,000, well, we'll do easier math, $900 that they pay in monthly rent. It may be unreasonable to ask somebody to pay that 900 plus another 300. It just might be completely unreasonable in their budget to pay $1,200 a month. So even though the landlord can ask for up to that 1/3 monthly rent, they still have to take into account what is reasonable. So they might have to bring that down. It can not be conditional or waive anybody's rights. So the landlord can't say, okay, great, you paid me the back payment that you owe me, but you didn't pay me the current rent. Therefore, you've defaulted on everything. You owe me current rent. Here's your eviction notice. And you owe me all this back rent all at once. They're two different situations. So whatever their payment plan is for the repayment of this back debt still stands, and then they have to enter into another payment plan for the current rent right now. So they have to have two different ones. Landlords also have to offer reasonable repayment plans on these specific debts. So remember the timeline there. If it is reasonable, the tenant has to enter into that payment plan within 14 days, or they have to plan for an eviction. If they do accept the payment plan, however, they have to stick to it. If they don't stick to it, the landlord can either choose to evict them or go after mitigation funds from the state. Cannot do both. They can't just evict the tenant and get money for that. They got to choose one or the other of what they want to do there. This is one where what is reasonable might end up being more court-based conversations. That is also where we get into that last slide that I was talking about, the eviction prevention slide, where now they have legal counsel to go to the courts and go, I'm being evicted for this 14-day pay or vacate. However, here is the background. Here is the payment plan that they offered me, and it is unreasonable due to how much income I make, how many other debts that I have outstanding. So the landlord actually needs to provide to the courts how they came up with what is reasonable for that specific tenant. So the burden's on the landlord to decide that. This will make changes to section 7 when we talk about repayment plans at the very, very end of when we talk about budgeting and credit. There's that one page that talks about if you have to make repayment plans, here's how you do it. So I'll add a note there for you. Okay, few more protections in this bill. This bill had all of them. Any late fees related to COVID, an individual still cannot receive any late fee notices for any of the rent that was due between March 1st, 2020 and that same timeline that I showed you on the last slide. Right now, it's looking like December 31st, 2021, but if the governor chooses to extend that beyond that time frame, it would go out until then. So no late fees on past rent or upcoming rent for 6 months. Tenant screenings. If a tenant does owe a past landlord and they decide that they want to move or they're trying to apply for a new place, that past landlord can't tell the future landlord, hey, this person owes me like $5,000. Cannot say that. However, it's very specific to landlord. So a past landlord could technically say that to a screening company, but the future landlord cannot take into consideration any past debts owed. So even if the screening company knows, hopefully they don't share that with the future landlord, but even if they do, that future landlord should not be taking that into consideration whether or not to rent to this person. So know that there's a weird one there. Yes.
I have a weird question. I just personally, so I moved from Oregon. I was living and working in Washington, so all this is relevant. I still work in Washington, and now I'm living in Oregon. But I just applied for an apartment, and they asked me. I've rented plenty of apartments in my life, and I've never been asked this before. They asked me to take screenshots of my last 6 months of payments to my landlord, and I thought that was really weird. And I was like, that totally has something to do with what's going on right now. I did it, but like I felt weird about it.
And that was Washington or Oregon?
Oregon.
Yeah, this is problematic even in Oregon. That
right? I was like, that's not, I'm a housing case manager. I was like, I really want this place, so I'm going to do it, but that can't be right. I've never had to do that in my entire life. It makes me think of this number 2 here.
Yeah, it also makes me think that you might be eligible to get about 3 months worth of rent back from that landlord for violating in Oregon SB 282.
We should talk.
We should. I'll send you info about that one.
Could I ask a question similar to that?
Of course, yeah.
Well, so I'm wondering if, and maybe you just answered it, but in Washington, is there any kind of provision if that does happen? If a landlord does do this to a potential tenant, can they? Is there some recourse for the tenant?
We'll get to that in a moment. Give me one sec. How embarrassing to now have that recorded too. Well, good luck in me at least muting that. Sorry. Yes, there is. Give me 2 more clicks and then I will share that with you.
Okay.
Down the right pipe this time. Good job. Okay. The other really exciting thing that this bill carved out beyond any COVID protections is you all now have a brand new protected class status throughout your state. Woohoo! So the protected class status is that a landlord cannot ask about medical history at all unless it's related to a reasonable accommodation. So if somebody is putting in a reasonable accommodation, they can go, hey, I need some verification of that disability so we can move forward with this. But a landlord can't just, for whatever reason, ask somebody about their medical history that is not related to a reasonable accommodation. Woohoo! Congrats. That's awesome. If a landlord violates any of the things that I just said, any of them, they owe up to 2.5 times monthly rent plus the court costs and legal fees that goes along with it. See, I told you, 2 clicks. So, the pages that these affect. So for the very first one, the COVID related fees, you can mention it in section 10 when you talk about fees versus deposits. And then we'll also talk about it again in section 12 when we talk about notices. For the tenant screening bits, you'll start talking about it in section 4 when you talk about screening and what landlords are looking for, as well as then when you're starting to look for a screen and go through William's screen, you'll see it come up there. And then, surprise, when it comes to another protected class, that deals with section 3, which is fair housing. And there's a few different places that I can put it in. So you'll see it on that page where it has the very call outs for location and the different protected classes depending on which location, as well as then we'll talk about it again with reasonable accommodations and modifications. So, ta-da. Any questions about that extensive bill?
I do have one question. I know the answer, but I'd like to check anyway.
Yeah.
Would medical information include information about someone's addiction?
Yes.
So in some ways, I guess I'm wondering, if they have a criminal record based on being arrested for their addiction, since that is also medical information, I'm wondering if they'll intersect in some way.
They can intersect because not all addictions are medically related. Like if somebody was on painkillers because they hurt their back and this became an opiate thing, that's different than somebody might use recreational and things that they get addicted to through recreational use. So I could see that being a real gray zone between those two. I'll be curious how they come up with that decision. I'm sure that there'll be a few court cases about it. I'll track them for you.
I'm always looking for loopholes.
Right. Criminal history. I'm gonna write it down so I can watch for it. Medical history. Okay. Good one. Okay. A few of them that are actually going to be pretty quick for us because they don't impact the book that deeply, but I did want to share where they come up. Is there was a bill that worked really hard to get all of the information across all of the Oregon statute or Washington statutes, and merge them into one specific code when it came to protective orders. There are quite a bit of different laws all throughout the code. And now what they're going to do is they're going to put them into one specific code just about protective orders and then really make sure all the language across these are all encapsulated in the same place and they all have the same definitions to them and make the most amount of sense. And into the new revised Washington statute code. Things that are really important for us is it's going to update the definition of domestic violence to automatically include unlawful harassment. So when we talk about survivors' rights when it comes to domestic violence, stalking, sexual assault, and unlawful harassment, we don't have to say unlawful harassment now because it's going to be codified under domestic violence. Other things when it comes to housing related specifics to this whole bill, it was big, so I just focused on those, is sometimes if an individual is leaving a household, whether they are the survivor or the perpetrator, if the survivor attempts to go get a protective order against an individual who's left the house or they left the house, there's a separation there. it wasn't always clear in law that they would get that protective order because now those two individuals aren't living in the same household. Why do they need a protective order? That's not going to be the case anymore. It's going to allow, regardless whether they're in the same unit or not, to still move forward with filing that protective order. And surprisingly enough, it's also going to allow individuals to keep their address confidential when they're filing those restraining orders or protective orders, which wasn't always the case before too. So those are the real housing specific. Unfortunately, because this is a large amount of documentation that all have to get moved back and forth, we probably won't see the rollout of this in the superior courts until January 1st, 2023, with the assumption that by January 1st, 2026, all of the courts across the land have now utilized this. It could be earlier than that, but they're giving them up to that time frame to do this. So it's pretty far out, unfortunately. Because it's that far out, I may not change the curriculum at the moment, but I'll do it in future iterations just to make it make sense. But any changes that it would be associated with would be in section 3 when we talk about protected classes and the rights of survivors. The other small one that I wanted to give a nod to is the limits of suspensions of driver's licenses, which I am really excited about. So an individual who failed to pay a traffic ticket is no longer going to result in an automatic suspension of their driver's license. Just because they don't have the money or the time to pay that fine does not mean that they no longer get the right to drive. That I think is really exciting because if you're thinking about somebody who maybe they got a parking ticket that they just can't pay, maybe they were speeding, right? It happens, I've done it, and they can't pay that ticket. And therefore now I can't have a car, I can't drive, I can't go to work, so I can't even pay this ticket, let alone any of my other bills. So it's allowing people to then have not just 15 days to respond to the infraction, but now it gives them a full 30. In that time frame, they can request from the courts to make a payment plan with the individual. So they still need to pay these. It just doesn't necessarily mean that they need to pay them all in one lump sum or they get their driver's license removed. And the courts have to enter into that payment plan with this individual unless they have previously granted that individual a payment plan and they defaulted on it and that payment plan is now in collections. So if they have already shown once that this person was not successful with that payment plan, they don't have to do it a second time. This I will probably change in section 4 when it talks about what a landlord is looking for in a tenant when it comes to criminal history. But it's not effective until January 1st, 2023. So it's still out a ways. So you probably won't see this change anytime soon, but it's around. It's exciting. Any questions about those two really small but important bills? Okay. And then from there, we get to go to our honorable mentions. These are bills that we were tracking that we thought were super cool and also didn't really have a lot of detail for us to add into the curriculum. A lot of it was funding sources. Some of them were to provide tax credits for folks who were getting energy assistance. We maximize the penalties when it comes to somebody who is being nefarious when it comes to debt collection agencies. That can go all the way up to, I think, an individual might receive a fine of $125,000 to $900,000 if they are being nefarious, and a few other things too. So I left those ones in there for you, but they won't really impact the curriculum that much. Any questions? No. Well, cool. That's it. That's all I got for you. Woohoo! We did it. Nice.
Thank you.
Yeah, no problem. Like I said, I'll send it to you, and yeah, thanks for being here.
Thank you. That was great information, but it's going to be hard to wait to 2023 or
I
2026
know,
for
right?
some of that.
I know. I know.
So,
Yep. All right. Well, cool. Thanks for being here. Yeah.
I had a quick question before you go.
Yeah, I'm here.
So, I'm working with some people that are pretty hard to place that have very extensive criminal records.
Okay.
But it's, I'm wondering, if there are any protections that people that have criminal records, um, have that I might not know about.
Mhm.
Um, and especially when it comes to crimes being committed, like 10 years ago or 15 years ago.
Mhm. Mhm.
And what I'm finding is that landlords seem to have their records going back forever.
Yeah. As long as they say how long in their screening criteria that they'll go back, they can look back as far as they want.
That's the main barrier I'm seeing with people
Yeah.
is they might have good credit, okay, they kind of rebuilt their lives, but they have this history that looks terrible. Um, I have one client, I think she's almost done with her rent well now, but she uh her the last incident was 2 or 3 years ago, and she stole the tube of denture cream so that she could go to a housing appointment so she wouldn't look terrible.
Mm.
And she got caught, and it's like it's just so ridiculous, and she's a
Mhm.
grandmother and doing really well in every aspect of her life.
Right, right. Um,
Um, Looking for some ways to mitigate that.
yeah, yeah. Unfortunately, there's not a lot of protections when it comes to criminal history itself. However, if you can connect that criminal history to any other protected class, that's the best way to go about this. I would also say I don't think that s- mm, Oregon right now is currently working on a bill, and I know we're different, but we're working on a bill that requires people to look and do individualized assessments when it comes to criminal history, which those individual assessments are important anyways when somebody talks about having a reasonable accommodation or modification that automatically needs to happen.
Mhm.
But Washington doesn't have a bill like what Oregon's trying to pass. I don't know where we're at with that one. Where it's just automatic, regardless if somebody is talking about a reasonable
Sure,
accommodation or modification.
but well, it sounds like it might be, most of the people I work with are
Mhm,
disabled.
mhm,
So it might be possible to claim
mhm,
that these criminal acts
mhm.
happen because of their disability. And so because of that, I'd
That's the
like
way
them
to
to
do this.
disregard it. Now,
Mhm.
um, I swear this seems to be landlords' resort right now because they can't deny people for other reasons.
Yep.
Um,
Yep.
so yeah, I'll try to go that way then. At
Mhm.
least at this point in time, landlords are still disability the fear of God in them.
Yeah.
So
Yeah.
we'll
Uh-huh.
use
Do
that.
that thing. Yeah. And also just telling them how much they've done since that time, right? And reminding them, th- it- I mean, honestly, when they look at the statistics, as long as somebody hasn't reoffended in 7 years, the likelihood of them reoffending again is almost zero.
Right, right.
So feel free to throw those into those letters as
You
well.
don't
Mhm.
happen to have that's or how could you point me to where I could get those numbers?
Yes, I can.
The landlord liaison in me also wants to say, I don't know if you work for an agency. I'm not familiar with you, Barry.
I
Sorry.
work for Share.
Mhm.
Okay.
Paper.
Okay. if I had a case manager that said I'm having difficulties getting placement because of criminal activities, I may send that case manager some property managers that I know are second chance landlords, or I know will work with us. You know, maybe that's charge a larger deposit or whatever that is. I have a handful of them, you know, that I know. So maybe there's someone that may be able to point you in the different direction as far as a landlord goes.
Okay, yeah, that is a good idea.
We are not used enough.
Yeah, this person, she's so she's made so many changes in her life, and she has a Section 8 voucher. It's a golden ticket, but she's had to get extension after extension because she can't. Now she's almost finished with her rent well classes, and she's on fire. And I, you know, I've been trying to help her now for 3 months, and I'm just so surprised. I placed people with some of the same places that she's gone to. I placed some really hard people, and for some reason she just keeps getting denied. So I think some of that may be the moratorium, and that landlords are being especially careful because they feel like they have a pretty large debt burden right now.
Yeah, that might be something.
I don't know for sure. So that looks just like my cat.
Yeah, she's sweet
All
and
right.
nosy.
Well, thank you. While we were talking, it occurred to me that it might be a useful thing to have a quarterly meeting of people that place people in apartments, whatever we want to call that, housing case managers or whatever. And maybe do some problem solving with people. Would you guys be interested in that?
Most definitely.
Okay, I think that would be invaluable because, you know, we take Rentwell and we try to use it, and I have to say Rentwell is really taught, and I've had the opportunity to teach a lot of classes because other Rentwell teachers would say, "Hey, can you do this for me tonight? Because I have to be somewhere else." And that it was great. It helped me overcome my fear of public speaking and
Good.
all the rest. So I think it's really valuable, but still, the questions come up and you go, geez, how do I do this? I feel like I should be able to do this, but how do we ask for a reasonable accommodation for this? And what do I do if this landlord does this? What's the next step? You know, like say a landlord denies somebody. Well, okay, they really denied them now. How do we go through the process of getting them to comply with the law?
Right. And move forward that way. Yeah. I will say that I have been so steeped in trying to get the online curriculum running for the last 6
Yeah,
months,
yeah.
and I have so many ideas after we can get to that point.
Oh, good.
I really think that it's going to free up a lot of us. So I know that we have the Brentwell Connect right now, and it kind of works, but it's going to work so much better, and you can connect with your other instructors so much easier. Like it's just intuitive now, and so that's exciting. I would really like to do like a ask me anything kind of ongoing basis too, and get a group that way. I threw out the idea of having a podcast there for a bit. So there's many opportunities.
Okay. Well, just keep the idea in mind, and maybe in, you know, a few months it'll be a good time, maybe in the fall even it'll be a good time to start looking at that. There's going to be more need in the fall.
Oh, most definitely.
So okay, well, I've got to be several other places, so I'm going to get going.
All right.
Thank you
Thanks.
very much.
Yeah, no
All
problem.
right.
Bye.
Bye-bye.